This is Industry Relations, a podcast that's at the intersection of real estate and technology from an insider's perspective, with Rob Hahn and Greg Robertson.
Hey everyone, and welcome to another episode of Industry Relations with Rob and Greg. This is your co-host, the notorious Rob Hahn. And as always, my favorite co-host, my only co-host, the fabulous Greg Robertson, rubbing up his mittens. Wagwan, fam.
I'm so excited about this. Hola, Rob. How are you, man?
I'm doing good, man. I'm going to start throwing in a lot of British street slang because I just finished watching Netflix Top Boy, which if you haven't seen yet, it's actually quite good.
Top Boy? T-O-P?
It's called Top Boy.
Okay.
And there's a lot of this British, Jamaican, street slang stuff. And one of my favorites has become this wagwan. Wagwan. It means what's going on. But,
Yeah, man.
But today's episode is actually a real special one because we have a very special guest that we're both very, very excited to be able to speak to. He's someone that we've mentioned in all of our, talks about the commission lawsuit, but we managed to get him on. So let's just bring him in. Mr. Ed Zorn. How are you, Ed?
Good, Rob. Greg, you guys?
Yeah, great to see you. I'm going to let the fabulous one kind of do the intro and just let the audience know who you are and where you be from, Hood, Blood. Where you be from, Blood?
Well, Ed, I really appreciate you being on here. For people that don't know, Ed's the Vice President and General Counsel of CRMLS, which is the largest MLS organization in the country. And, he's also, I think he's got a lot of great background to kind of add to our discussion here because you were a plaintiff attorney. You were also a mediator. So you know how these kind of trials work out with settlements and how you would present some of the stuff in trial. And you've been whispering in my ear a little bit about some of the stuff that's going on. I know that you're one of the, listen, there's a lot of people that remember this club, which is the yelling at the radio or yelling at your podcast player club. Hopefully that's mostly to Rob, not me. Okay. Cause I hear that I'm screaming at you. You don't know what you're talking about. So it's probably a 50-50 thing there. Yeah. But welcome, Ed. And thank you so much again for joining us.
Great. Yeah. Thanks for having me. I'm glad to have the opportunity to chit chat with you guys a little bit and maybe bring some insight. Probably at the forefront, obviously with my role with CRMLS, I do have to disavow the fact that while I'm a lawyer, like Rob says, I'm not your lawyer. Mm-hmm. And also the things I'm going to talk about are just my opinions as, one guy who's observing some things in the industry. This is not, CRMLS's perspective.
Yep.
Right. Art Carter does a great job at leading the organization and I get to give him some advice, but he doesn't have to follow it. And sometimes he doesn't, which is probably the wiser way to go. And, so this is just my opinions. This is not, the policies or concepts of CRMLS in any way.
Right on. So appropriately disclaimer, why don't we start at the obvious place, which is Burnett, unless we have some shocking developments like later today, over the weekend, it's going to trial on Monday.
Yes.
Right. And 2 of the 5 defendants have settled, and we're going to get into some of the settlement things. But just on top of your head, and what do you expect we're going to see come Monday? Or let's just say next week.
So, yeah. So the way this trial is going to probably lay out is it's scheduled for 3 weeks. Some things we know for certain already. The plaintiffs are going to get the whole first week. So all next week could be a little ugly for us on the real estate side, right? We're going to get the reports coming out daily, probably, the kind of testimony that's coming out about the practices that are being, that are criticized, from the plaintiff. So you're going to see that all of next week. I think some things are going on right now. Right now, the jury selection is going on as we speak. Right now, this is, obviously we're talking on Friday before the trial starts.
Really? So it's still going on?
I believe it's today is jury selection.
Okay, so they will have picked the 6, and then they will seat the 6 on Monday.
Correct. That's the idea, as long as they get through. Some things we know about the jury. There will be no homeowners on this jury. The reason we know that is one of the claims the plaintiffs are bringing is for an injunction, right? A request to modify and change the rules of NAR. Well, you think about that, it means that anyone who currently owns a home could be impacted by the outcome of this case because there'll be a different set of rules to move forward under. So as a result, that bars them from being able to sit on the jury. So there'll be no homeowners on this jury. And then the rest are people who couldn't, talk themselves out of a 3-week trial.
Right.
So that's going to be, your jury pool. And so
Before you leave that point,
week.
I've been mentioning that, in my opinion, there will also be no realtors or family members of realtors on the jury. Is that?
Oh, definitely. Yeah, that is absolutely will be the case. Yeah, normally those types of, again, anyone who would be potentially impacted or immediate family would be impacted by the decision, as a general rule, is not permitted to sit on a jury.
So we're talking about 6 renters.
Yes, and NAR hopes that what we're looking at is maybe a couple of retirees who are renter.
Well, previous homeowners are okay.
Some
right?
Previous homeowners, right, that have maybe have multiple sales in their career. That would be a good person for NAR to want to have on the jury. But yes, currently people who don't own a home.
And so just to clarify real quick, Rob, we're recording this on October 13th.
That's right.
So the trial starts is it the 16th, right?
Yeah,
Monday, 16th.
Yeah, Monday the 16th. So just for, yeah.
Right. And our episode goes out Wednesday the 18th. So
yeah.
So we'll be in the middle of the plaintiff's presentations by the time you guys start listening to it.
Exactly.
And if you've ever seen that, ever been involved in that, it's like the worst because it's always the last person you listen to that convinced you, even if it's not on your side. It's like, so it's awful, right?
Yeah.
All right.
It's a process. Yeah.
Yeah.
So real quick, because the civil jury, it's for sure 6 people, not 12. 12 is for criminal. And there'll be like 2 alternates?
In the federal court in Missouri, I'm not sure how many alternates they would have, but normally there are a couple of alternates so that if a juror gets sick, something happens in their family emergency, they can have someone who's been in the courtroom listening who then can take the seat to participate in the deliberations, which will happen 3 weeks later.
Okay. All right. So the first week is plaintiff's presentation. They get to go, again, we're basing it on like court drama that we've seen. And then the defense can get up and be like, I object, Your Honor, do all that stuff. But they don't really get to like cross-examine. Or do they get to cross-examine next week, or is that during the?
No, NAR will have the opportunity to cross-examine witnesses next week. So the plaintiffs will put their case in chief forward, right? They're going to try to argue that, the sellers have been damaged by, paying too much in these agreements. And because of this rule, NAR is going to then cross-examine those witnesses and try to, move forward with the concept that these rules are good. They help the community. It'll be interesting to see what happens. One of the other things we know is that there was a motion in limine. So if you recall, previously there was a motion for summary judgment. In that motion that was denied, which again was no surprise, the court said that there's a potential that the case would move forward on a per se ruling. So when you have a price fixing case, it is considered to be so egregious if there's an agreement to fix prices that there's a concept under the law that there's no offsetting good that can be done if you're fixing prices. And so you wouldn't be able to show or demonstrate the benefits to consumers as a result of the rule. And the court hinted pretty strongly in the motion to summary judgment ruling that he saw this as a per se case. Well, some good news for NAR and the corporate defendants there were some motions in limine, a few dozen that actually might have been like 40 or 50 that I reviewed before the case started. A motion in limine is brought by the lawyers to kind of pre-argue with the court what kind of evidence is going to be allowed and what's not. So instead of the high drama you see on TV where someone screams objection, we try to get rid of as much of that as possible before the trial even starts, so that the jury doesn't get information that's not rightfully in front of them. Because the reality is it's hard to disregard something you've heard. And one of the arguments that the plaintiffs tried to make was there should be no evidence about the benefits of this rule. And that NAR should be barred from bringing any such evidence. And the good news is NAR won that argument. The court is going to allow, at least at the beginning of the process and the beginning of the case, evidence about the pro-competitive aspects of these rules. Now, can the judge change his mind anywhere in the process? Absolutely. If at some point the court feels like the bar has been met, that a price fixing conspiracy or scheme has been, properly proven, then could he stop that evidence from moving forward later on in the case? Yes. But at least at the beginning, NAR has a plan to assert the pro-competitive aspects and then handle any issues at the jury instruction level.
So this is really critical because as you and I have talked about it and like our offline conversation and whatnot, one of the big things that I really focused on was that summary judgment motion where Judge Bao, I think that's how you say his name, in the Burnett case is like per se analysis applies. And so you said it's a clear, strong hint. I felt like it was a ruling, but maybe I'm wrong. Like, so how do you see that interacting with the motion in limine?
So it's clearly not a ruling at the motion. Remember, when you do a motion for summary judgment, the judge assumes, right, that the facts for the plaintiff that they have put forward are all accurate and true. Mm-hmm, mm-hmm. And then he has to make his ruling based on those assumptions. So based on the assumptions of all those elements being true, he hinted that per se might be the way to go, but he acknowledged that those things may not be true. There may be countervailing evidence. There may be evidence against that, or they may never actually have a sufficient amount of evidence to actually put in the trial. Maybe there's an evidentiary objection. So what they were going to use to prove that point won't see the light of day, right? So he has to leave open the fact that NAR's argument can carry the day.
So when would the per se rule come into play in this trial? Because it is a jury trial. Is it at the jury instruction stage where the judge would say, hey, listen, per se analysis applies. So when you go consider the evidence now, ignore all of the positive pro-competitive benefits. Like, is that when it would actually be ruled?
So no question will be part of the jury instructions.
Okay.
Right? That's NAR's desire. The plaintiffs, though, if the plaintiffs feel like they've put forward a sufficient amount of evidence to convince the court that the first threshold has been that there is this agreement, could the court decide when NAR is moving forward and putting forth evidence that the evidence that NAR is putting forward would be confusing or more prejudicial than probative? That's the evidentiary standard that the court uses to determine whether they're going to let it in. That's when that would be done. So my thought is that as NAR has the freedom to cross-examine, ask questions, push back against expert testimony, will the pro-consumer aspects be allowed? I think so, entirely for the first week. The question's going to be, as NAR starts moving forward, will the court still give NAR that latitude? Because there's the concept that you can't unring the bell. It's super easy as a lawyer to say, hey, Your Honor, let me put all this evidence in that I want. And if it's not appropriate and it doesn't meet the mustard or carry the day in your eyes as the judge, just tell the jury to disregard it, right? So even though you sat here for 2 weeks, listening to us to drone on and on for 2 weeks, just disregard all that. That's okay. Courts don't like to do that. So the judge will weigh in probably sometime in that second to third week, and we'll get a little indication of how that argument is going.
So basically, there's a scenario where, let's say even by Friday or, next Friday, the Monday after, the judge could come out and be like, hey, we are the plaintiffs. Hey, NAR, you got to cross-examine them. I'm satisfied they met whatever. We're going to do per se going forward. So shut up about the pro-competitive benefits. I mean, that's a possibility is what you're saying.
That's a possibility. And then you could just chalk that up as one more thing to put in the bucket that NAR will have for an appealable, that's an appealable ruling, right? That the NAR be able to argue, hey, that's an error. We should have had the opportunity to argue that and let that issue go to the, those kind of elements will be what will happen.
All right. So can I just get the non-attorney guy fucking thing in here, right?
I was hoping you would chime in. Otherwise,
yes.
Ed and I are going to start talking about federal rules of civil procedure.
Did you ask for a commissioner? Goddamn right I did. So did you say commission was free? You're goddamn right I did. So Ed and Rob, just real quick, one word answer. Ed, do you think NAR is going to win this lawsuit? Yes or no? One word.
Maybe.
Oh,
You're asking a lawyer for one word answer?
come on! I just intuitively.
I can. So here it is. NAR can win this lawsuit.
Here we go.
Right. NAR
Sorry?
can win this lawsuit. They can't, even on a per se basis, Rob. I think even if the court rules per se, NAR can win, because I think there's definitely an argument that can be made that the sellers were not damaged. Sellers don't pay the buy side commission. The buyer does. And to the extent that that argument is out there, NAR wins. If NAR also has some technical arguments around whether these sellers are the direct purchaser of services or not, that's another very technical. I won't bore your audience with, the Illinois brick case and all of that, but there are some technical arguments that NAR. So there is still a chance that NAR wins on the emotion of it, on the and this happens with juries, because I tell Art this all the time when he says, hey, what's our risk here? Well, I'm going to tell you, if you have all the facts and all the law in your case, you got about a 25 to 30% chance that you're still going to lose. Right. And that's because juries don't follow jury instructions. Juries don't follow complicated analytical contractual chains through evidence. They don't care. They just do what they want to do, and they do what they think is right. And the jury instructions and the law be damned. Right. And so that's why there is no one solid. NAR can absolutely win this case. Is it an uphill battle because the plaintiffs hold the emotional cards and the heartstring arguments? Yeah, that sits on the plaintiff's side. I can tell you, though, I'm not very impressed by the plaintiff's trial briefs at this point.
Rob?
I mean, I'm already a record. I think and for me, it was twofold. It was that it's a jury trial, right? And that it's per se. I think it makes it very hard for NAR to win. And if the judge comes out early with per se, so if by Friday it's like, listen, it's going to be per se, so NAR shut up about the benefits, yes, NAR could appeal that ruling. I don't see how NAR wins this case.
But I mean, it is back with what Ed said. I mean, it's that bell is rung, right? I mean, they could still have that in their heads, right? So,
but even on a per se ruling, Rob, it doesn't matter from the standpoint that even in a per se case, and even if there is quote unquote price fixing under the per se rule, it doesn't matter. These plaintiffs that are sitting in front of the court today were not damaged, right? Because the buyers are the ones who paid the fee, not the sellers. So that's still an argument that is available to NAR, even in a per se case.
That may be the case, Ed, but here's the thing. Like, number one, I've not yet heard NAR mention that one single time.
That's my concern.
Right? So if that was such a strong
thing. It's a back pocket thing. They're bring this out, man.
Yeah, maybe. Number two, one of the reasons why Leader versus NAR was dismissed, right, by Judge Woods. Now, granted, it's a different judge.
Right.
But the same judge who's doing Murrow versus NAR, Leader versus NAR was brought before. And that was the one where the buyers were suing. And she was just kind of like, listen, I'm already dealing with the seller side of things, so let me get through that first. And I think she dismissed it without prejudice. I don't think it was with prejudice. I think she said, right? Like, just hold off. Like, let me see if I could deal with this at the seller side. Yeah. And then really the other final thing for me is I think it's the claim is not that the sellers are damaged per se. It's the whole claim is this system that NAR and the MLSs, the cooperative compensation, raised the price of everything. Right. So I think to me, again, I'm thinking about arguing in front of a jury of 6 renters who couldn't get out of jury duty.
Right. I'm agreeing with you here.
So I think they lose.
Yeah. I'm agreeing with you here that it's an uphill battle on the emotional, just objective, hey, this isn't fair kind of layer. I understand that the plaintiffs have an easier road to hoe on that. But yeah, it's trial, baby.
And can we,
it can happen.
Yeah. Can we rewind here? Because I know that some of the listeners will be just like me and go, just explain in like I'm a 5-year-old when you meet per se, right? You've been saying that. And I think I understand it, but maybe somebody could just, as you're speaking to a young child, what that means here.
So there's various standards that get applied with regard to what you have to prove in a case. And when you're dealing with a price fixing, let me start this way. The typical antitrust case what you're supposed to do is there's some kind of anti-competitive thing. Let me use an example in our industry. Exclusive listing agreements. You do realize none of you sign an exclusive listing agreement to go to the dentist the last time you sat in a dentist chair. And there's no agreement between the dentist groups that says, hey, if Greg sits in my chair, the dentist down the street is not allowed to talk to Greg for the next year. And if you do talk to Greg, we're going to fine you $15,000, right? That would be considered antitrust violation, right? That's against consumers. Dentists should be able to free to get customers as they want, right? So it's clearly going to hurt the customer. We get that in real estate. Why? Because that is a necessary element for the functioning of the multiple listing service to encourage listing agents and sellers to put properties into this community where everybody sees it. Cooperate. And when you weigh the restrictive nature of what an exclusive listing agreement is against the pro-consumer benefits of the MLS itself, the MLS greatly outweighs and is so much beneficial compared to the restriction on you getting a new client that is placed. That's called the rule of reason. And we put this on a scale. And what the judge is saying, what the law says, when we're talking about price fixing, and there's proof of an agreement of competitors to fix prices, there's no amount of consumer benefit that you're ever getting from that we're ever even going to put that on a scale. Price fixing is so wrong at its core, it's per se a violation without having to weigh anything against it. So I don't know, Greg, if that maybe helps.
Yeah. Okay. Yeah.
So let's move on slightly. Actually, before we move on, I did have a question for you because of your background as an actual litigator, actual mediator. In the settlement, and I'm assuming the same holds for anywhere, but RE/MAX settlement clearly says that they agree to cooperate and that up to 3 executives will testify. And I think it's only in Merle, I think. So the question is, do you anticipate the plaintiffs actually calling one of, I don't know, Nick, to the stand and saying, testify for us? Do you anticipate anything like that happening?
This is an excellent example, as I heard you guys talk about this, where I scream at the radio and turn it off. Okay. All right. is your guys' description of what cooperation is. So in a case, when you're litigating, when you're a party to the case, I have certain rights as an attorney to force you to go to trial, to get documents out of you, to have you sit for depositions. Right. And I don't have to chase you, where if you're not a party, I have to do subpoenas, and there's a different set of rules that are more complicated and protect you better when you're not a party. So now when we get to a settlement with somebody and they're going to leave the case, and this is why it was in Morrell that you referenced this, right? So they're going to leave the case, but I still want to call them to testify. I still want to use and have them authenticate, because I may want to still use some of the evidence I gathered from them in my case against the people who remain. I don't want to have to chase you and follow all of the non-party hassles that happen as a lawyer. So every settlement agreement I've ever seen has this cooperation clause in it. It's not that I'm going to cooperate and help you win your case. That is not what they agreed to. What they agreed to do is, if you send me an email that says, go to court on this day, I promise that I will show up. And if you're going to ask me questions about authenticating documents or business records, I'm going to authenticate that. I'm not going to fight you, throw a bunch of objections up, and make that road harder for you just because that's what we do as lawyers, so we can charge you more money, right? We create all of this chaos. It's great billable events. And I'm not going to do that. That's what cooperation means. It has nothing to do with my requirement.
Turning state's evidence or something.
Yeah, that's
right.
not a thing. Not at all. Everybody has a duty to tell the truth, and that's the duty. And I'm not going to help you prosecute your case. I'm just not going to put hassles in your way. So it's got nothing to do with helping you move your case forward.
Okay. So moving on to that, I guess one of the questions I fully expected, because the RE/MAX settlement was so generous, so cheap. I fully expected KW and Home Services to settle. I know we still have a few days, and I know you could settle in the midst of trial, I believe. What's your expectation? Do you think those guys go the distance? NAR has come out and said, we're going the distance, right? They made that very clear.
Well, that's what they would. I would say anybody would say that.
They
right?
could settle
Anyone who
too.
has not signed a settlement agreement is going to say they're going the distance.
Yeah.
Let me tell you this. So I've handled hundreds of cases. Now I'm going to go back to my plaintiff days when I was an attorney. I have had people yell in my face the day before trials start, I will never pay you X dollars.
A goddamn single dime. Yeah.
Right. Well, not even a single dime, right? But not over a certain millions of X, right?
Right.
And we show up the next day, answer ready for trial, and guess what? They quadrupled their last offer and paid me triple what they told me they would never pay me. Right. So that happens constantly. So I don't put much stock in that. I think what you're going to see is Keller Williams will probably settle, right? Probably here in the next few days. I think the hardest one to settle is going to be the Berkshire Hathaway, grouping of defendants.
Okay,
and the reason I say that is they're structured well. They're a well-run machine, right? With company after company, with subsidiary, with the grandmaster at the top, who is doing what? Reaching in every month or every quarter and skimming off all of the profit, which is exactly what you do if you own a company, right? Greg, maybe you did this with W&R Studios, right? Every month you go in and you go, hot damn, we made so much money. We just throw that into Greg's personal bank account, right? And the next month, W&R Studios has no money to work with, right? And that's fine. That's legal. There's nothing wrong with that, right? Having the owners take dividends out of the company is legit. And I think that makes it more challenging for the Berkshire Hathaway Home Services groups to resolve because they're probably sitting on very little money. I think there's a motivation for them to still settle at some kind of number because really the plaintiffs would have a threat. Hey, you know what? If this doesn't work out, nothing stops us from filing cases against your biggest brokers and taking the same case going directly against brokers, right? Because you don't have those protections that we're giving the other settling parties. Realize all those other settling parties, it doesn't cover just the corporate entities. It covers each of the individual brokers and agents and everybody underneath. So I think there's a motivation to settle, but it's a much lower motivation. And that's why there's a chance that I also think specifically with the corporate defendants, I've always considered the case very weak against the corporate defendants. To prove that they were involved in the creation of an operation of this scheme is not easy to do, right? This scheme predated all of them. All of them. This system of how commissions are shared and all that always existed. So that's a very uphill road for the plaintiffs to hoe in trying to get that done. So I could see someone like a Berkshire Hathaway saying, well, we'll take our chances at trial. And remember, you have some likely spots where people settle. After the first week, if things go horribly wrong for the defendants, that's a settlement point, right? Right after the trial, before an appeal bond hearing, another excellent point, right? And I think that's the most likely spot for NAR to sit if NAR doesn't outright win.
Let me ask this to you, Rob, going on like just my last question. We've been pontificating on this pod about the value of NAR, right? Because of all the things that are going on, people leaving, whatever.
Yeah.
If NAR wins this, right? And just like they won the DOJ thing and these guys have been actually fucking taking names, right? Mm-hmm. If NAR wins this, can you say, hell yes, these guys deserve every goddamn dollar I've sent them? Because this is really getting at the heart of the matter, right? Of me being a practicing real estate agent, right? I mean, can I posit that a little bit? What do you think?
I'm curious what Ed thinks about it. I think the answer is not yet because sure, NAR could win, but I think the plaintiffs could appeal.
Okay, but they win. I'm saying they win, right?
But I'm saying plaintiffs could appeal, number one. Number two, the DOJ has gone nowhere. So NAR is not out of the woods, right? And if you're saying the value of NAR of the $1,400 a year that you're paying as a realtor member is because of winning at lawsuits, I think that's a weak That's pretty weak.
Well, winning a lawsuit that basically goes to the underpinning of how you get compensated. I mean, that's fucking something.
Like I said, you're not out of the woods, but that's my take. I mean, what do you think, Ed?
I think you both have a point. Damn, look at me being lawyerly. So I think Greg is right that NAR should get lots of kudos, lots of credit to go to the leadership and the attorney group.
Everybody's been giving them shit. Everybody's settled, do all. I mean, me too, right? I mean, everybody's been giving shit.
Right. Kudos to them if they pull that off. That's a great thing. And NAR should get lots of credit and a lot of love for that event. At the same time, commissions are still leaving the multiple listing service and will not be allowed in the MLS, right? Because the Federal Trade Commission is going to take that event and they're not going to wait for an appeal. They're going to say, look, plaintiffs had their shot. Consumers tried to right this ship. The system and the way the laws work right now didn't allow them to do that. Here we come, FTC, DOJ, and say, nope, shut it down, yank the commissions out of the MLS and move on. And by the way, and I've gone on record as saying this, I also don't think that's a big deal whatsoever. I don't think it matters that the commissions leave the MLS. So what?
Right.
No, I actually think it could be a positive thing. I mean, I think transparency is a better thing for us as an industry, for sure.
I think it's better for buyer agents.
Yeah. I've written that. I said, look, this could end up being really beneficial. Going back to the DOJ, like Lena Khan and those guys aren't doing too well on their antitrust stuff. They lost to Microsoft. Right. They lost to I forget the other one. Now they're trying Amazon, right, which is her bread and butter because that's where she started. So they're not doing too well with a lot of the things that they've tried to kind of change. So I like the odds.
Yeah, and that's why I say the FTC would just come out with a rule. I don't think you necessarily have litigation, right? Why should the DOJ fight against a ruling that is already against them? Why don't they just hand it over to the FTC and just write a rule? They don't need to file a lawsuit, right? It's not like they're stopping the merger where Lena Khan can't win a case, right? She just has the authority to add a couple of sentences to some code.
Yep. Let me ask one more question on that's a little wonky here, because when I've talked to both of you guys, we bring this up, and this is like they have to, like you're saying on these settlements, it appears they're saying all their franchisees. Is it only in those states that this is in, or have they expanded the class? I think is the words that you guys are using. So, I mean, because that's been a rough thing with you guys is like, well, they could settle this, but it's still going to invite copycat lawsuits. I mean, are we out of the woods with the copycat stuff based upon the settlements we're seeing, or this was going to
be my question for Ed as well. So this is perfect. Yeah, basically, Ed, let me reframe it in my settlement class, right? It looks like they're talking about a settlement class that's the entire country. What's the likelihood of success and acceptance of that?
Absolute. That's normal. Right. It is normal to have a class action lawsuit that is in a smaller jurisdiction, a smaller group. And then when you settle, like in this case, here's where the argument goes, right? You guys all watched and you all read the class certification motions and you saw all the categories. And one of them was, do these class representatives represent adequately things that are happening across these 20 marketplaces? If we use Morel as an example. So all you do is you stipulate, right? And this is what the agreements do. The parties stipulate that the plaintiffs in the Morel case and the Sitzer case, and by the way, the MLS PIN case is involved in this, right, are representative and the claims and everything are exactly the same for the whole country. So we're going to expand the plaintiff class. And instead of just the plaintiff class being in these 20 markets, plus Missouri and MLS PIN, we're going to make the class every seller in the whole country in the last 4 years, right? And by doing that, you expand that class around the whole country and everybody gets the protections, right? Now, for that.
And then, Rob, you would argue that that was you can't do that. It's got to be a law or something.
I think it's because I read a couple of Supreme Court cases where I said the asbestos lawsuit. There might be a different issue here. So I'm like, maybe, I could be wrong about that. I mean, I can't remember the Amchem. I think Amchem products is the case. It's different.
But remember, on those cases, what you had was that those settlements related to future claims from people who didn't even know they were hurt yet. So you had a lot of logistical issues on those asbestos cases because you're setting up a class for people that don't know they're damaged, don't know they're a member of the class, and it needs to last 30 years. None of those parameters are here. None. Right. This is backwards in time, much easier to administer. We know exactly who these people are. No one's going to get added to that group. Right. So I'm going to suggest to you the court will have the authority and the capability of expanding the class so the plaintiffs can.
That's great news.
The whole country.
That's great news.
Yeah.
If there's a settlement. So
if there's a more global settlement. Right now, it's only covering the franchisees, the brokers who are part of the people who settled, right? But if NAR resolves this, and I know this for a fact, right? NAR said this multiple times. They will not settle this unless it is global.
They shouldn't.
MLSs,
they shouldn't.
AORs. Yeah, they shouldn't. Right.
Yeah.
All the brokers, right? So, but they're also open to it. I don't know if you saw the last statement that got sent out by Katie to kind of all the AORs of, hey, we're going to start trial. Here's what we're going. There was a sentence in there that specifically talked about the fact that, I think I have it right here, right? That NAR has always been open to resolution outside of the courtroom, right? So that's still on the board. Just because you're going to fight hard in court does not mean you won't consider an opportunity to resolve it.
So 2 questions, and they're related, trust me, right? So the first question is, does the court ever reject a settlement because it doesn't provide enough in damages to the plaintiffs? So, have you ever seen that happen in a class action?
It can, right? You saw a little side of that in the no select case for MLS,
a little bit, right?
Where all the money went to lawyers and nothing went to the plaintiffs, right? So you saw the judge interject herself to say, no, this is not fair. We need to take care of the plaintiffs that are here. But the reality is, and Rob, I know you've talked about the 20 billion, 600 billion, 50 trillion, whatever. My point is, as a plaintiff lawyer, I used to tell my clients this all the time. Imagine you're in Vegas and it's a slot machine, right? For me to take your case, I need 3 things. I need a cherry to come up with someone who did something wrong. I need to be able to find and have a defendant, and then that dude better have some money. And you're only going to get money if all 3 line up and pay out. So this case doesn't matter if it's 2 billion, 20 billion, 200 billion. The top number is meaningless and utterly irrelevant. The only thing the court is going to look at is how much money is part of the settlement. What if we didn't settle? What is the best outcome the plaintiffs could expect from a money standpoint? They're never seeing more than probably $1 to $1.5 billion ever with this group of defendants, right? So that's why I think you're going to see these defendants get these settlements approved, right? The plaintiffs are taking half of these guys' cash. That's rational. That's a fair number.
Okay. So the follow-on question is, because every class action settlement, of course, has the opt-out provisions.
Yes.
And this is part I just don't know. Is there such a thing as a class action opt-out?
Yes. So what you ever get those little cards from Target or your cell phone company charge you, and you got that $3?
Yep.
With that white card, if you ever actually read one, that's your opt-out option.
I know. But what I meant is, so if you opt out, right, do you have to bring the lawsuit as an individual plaintiff, or can you bring it as a class action? No, there's a class of people who've opted out.
No. So you can only bring it as an individual. So
that was my question.
Is the class action for this event. If you want to be
right
part
on.
of the class,
Good news.
This is how you do it. Now, if you don't have to be part of the class, you can say, hey, my $350 that I'm going to get out of this is not enough. I want to go sue for my $3,000.
Right.
Well, go have at it. Right. But you do not have the right to set up a brand new class of all the people who opted out. That's not a thing.
That was my question. Right. No. Because again, I mean, I think one of the consequences of this is, okay, let's say it's $1.5 billion, like you said, let's say $2 billion or whatever. Right. Mm-hmm. And the settlement class is the whole country.
Right.
I'm like looking at this, okay, you've gone and told all these plaintiffs, hey man, you got overcharged by these people and you paid an additional $15,000 or $30,000 that you didn't have to.
Well, there's no admission of guilt though.
Granted, I'm just saying, but as part of the settlement, you're going to get $3.
No, part of if it's a $2 billion settlement across the country, you're going to get more like what, $350?
Oh, sure, 350.
Right.
I don't even think it's that much. I mean, how many sellers are we talking about?
Yeah, we can do all that.
2015.
I understand your point, right? It'll be it'll be, let's say, a few $100s.
Let's say $40 or whatever, a couple $100. And I'm like, but I paid $30,000. Like, screw that? I'm opt out.
You'll never
feel like
no, you won't. No, you won't. You're an idiot if you opt out.
Yeah, God, the lawyer fees alone on this kind of
$100,000. You're gonna go hire a lawyer for $100,000, have your life disrupted for 4 years, so you can make some kind of argument, which is somewhat of an uphill battle, all by yourself,
right?
So that you can get $30,000, and you're going to cut a check to your lawyer for $100,000 for that. Nobody in their right mind is going to do that.
Okay, so and that's why the absence of. So in other words, like let's say 5 million people opted out, you still can't have a class action of the 5 million people opted out and say, look, we're all the same and we're going to go do this.
No.
So that is not a thing.
No, if you this is the scenario, right? This is the case. You can have the benefits of everything that happened in this case that, by the way, cost you nothing. Or you can opt out and go at it on your own. That's the condition.
Okay. Cool. So let's say there's a settlement. Let's say all of those things happen. The only real threat left at that point is the DOJ and the FTC, because obviously they are not parties to this.
Correct.
Right.
But, I saw a panel at CMLS and I thought this was a good point. I forget what attorney talked about this, but in the case of MLS Penn, right, they objected. And I think the way it is right now is that we're waiting for the DOJ to say, okay, well, what do you want? Because as the attorney that made the point on stage is like, we've never really heard from the DOJ. Okay, exactly. Okay, so then you tell me how you want to do this. You've been hitting, this isn't good. This isn't good enough. This isn't good enough. Now it seems like the ball's in their court to say exactly, well, this is how we'd like it structured. I mean, part of it, what I guess the hints we're saying is like, it's not they don't want to have a field they don't even care that the offer proposition is now 0. They don't even want a field on the MLS or anywhere that even talks about that stuff. Right. So that's a little bit of a hint, but, yeah, I mean, I think we're going to find out a bit more before we have to. That's going to inform the industry of like what exactly they're looking for, because I don't think we've ever been told by them what exactly do you fucking want from us.
And they're unlikely to tell us. That's just the way government works. So
they're going to come back being some opaque thing again, huh? Jesus.
Yes, you take the most inefficient way of doing anything, and that's what this process is. And so, but we do know some things already, right? That it's clear that they don't want compensation in the MLS at all. That they want buyers to pay the buyer agents in total. That listing agents need to be paid by the seller. That there needs to be a full decoupling. That's clearly a standard that they're fine with and that they will like, right? And again, it's not a big deal. It's totally fine. Where the DOJ, I don't see the DOJ getting involved.
Well, it's not totally fine if the buyer's commission cannot be folded into the loan, I think.
But it can.
Right? I think. Okay. Well, if that's what I'm saying. I mean, if with that caveat, because if you're going to ask, so I just wanted to mention that. Yeah.
No, it can be, right? So, and I've always used, this is the example I used from stage at CMLS last week, right? I'm a commercial practitioner, right? I've done 250 closings, never inside of an MLS, no offer of compensation by contract made ever. And what we do is, number one, we get a representation agreement signed before we start working. And then when we negotiate the terms of that contract for the purchase by my buyer, I include a paragraph in the purchase agreement that says, seller, you're going to pay my fee. And that gets buried in the purchase price, exactly like it gets done today. You do realize under this system of the seller paying the buyer's agent directly inside the contract, you do realize a closing statement at a title company or an escrow company looks 100% identical as it does today, with both commissions on the seller side. Nothing changes. The only thing that changes is the number that shows up for the buyer's agent in that closing statement was negotiated between the buyer directly and the buyer's agent. It had nothing to do with the seller or the listing agent. That's the only thing that's different. So you're going to see different numbers there. Different than what the seller negotiated with their own listing agent, right? That you'll rarely see the same number there, potentially.
So do you think, I mean, this is a little bit kind of the Northwest model, right? Northwest MLS model.
No.
I mean, because I thought that's, well, I guess the seller put that in there. It wasn't negotiated between the buyer. Well, no, it ends up being negotiated by the buyer's agent.
So here's where it's different. In the Northwest MLS model, there's still an offer of compensation from the seller. So there's still a number in the MLS that the buyer's agent is putting.
It could be zero. It could be whatever.
Could be whatever. But the point is, the number, Greg, is determined between the listing agent and the seller, not the buyer.
Yeah, right. So, but at the end of the day, it does turn into a negotiation.
Correct.
Right? Because if you put zero down there and a buyer's agent shows up and says, I got an all cash buyer willing to put a full price offer in, but my commission is 2.5. You know, who fucking cares what they put in that type of thing? If the seller's like, fucking A, I'll take that.
Yeah, but that won't ever happen that way, Greg, because if you have an all cash buyer, tell the buyer to cut you a check for your 2% or 3% or 20%, whatever the number is, right? Where it's going to matter is FHA, VA. It's your first time homeowner.
Yeah.
What you're going to see, what I predict you're going to see is on your first time homeowner type of home, maybe the first level move up, you're going to see sellers very willing to include the buy side compensation request in their contract. On luxury properties, right? The scenario you said, I'm going to buy a $5 million house for all cash. As a seller, I'm going to take a pound sand, cut a check for your own guy. Right. In the middle, you're going to have kind of 50-50. Right. If I've got a previous sale, I'm coming out with $200,000 or $300,000 cash. I don't need help to pay my own agent. But if I need help, the sellers will help because it makes their property more marketable.
Right.
I have a question actually directly related to this, Ed. And this is something I was asked and I just didn't have the answer to this, right? Which is there a limit to the injunction power of the judge?
Yes,
here's what I mean by that, right? So let me set this up. We know that like the FTC as a regulator could write whatever rule they want. As they could write some regulation that says, hey, exactly what you described. Here's how it's going to go. Buyer agent, you have to go get an exclusive agreement. Nothing will be in the MLS. And you have to include this in the purchase agreement and negotiate it with your buyer's permission, blah, 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 right? With injunctions, I feel like judges don't really have like the power to create regulations, craft. Like that's not really what they do, right? So what's the limit of the judge's injunction power in this Burnett case?
Right. I would suggest to you sometimes that it is what they do. That's why we read the Wall Street Journal and other news reports when they get overturned. So we had this discussion amongst a bunch of us lawyers, right, of exactly this question. It's a little open-ended, right? Because here you have a federal judge. Mm-hmm. I understand the class of damages is the state of Missouri, right? But he's going to be asked potentially to issue an injunction to do what? One, the soft injunction, I think you guys, as you phrased it, right, is simply an injunction to tell NAR, you must remove your mandatory rule to offer compensation, which is utterly meaningless at this point. And I'll be honest with you, it was utterly meaningless before NAR changed the rule from $1 to $0. Right. To me, the whole issue about the mandatory offer is a red herring and means nothing to this discussion. Right. Because the fact is every MLS system would take $1, which is the same as 0. It's nothing. So that's one issue, one road he can go that will still do nothing. Then he could also go the other extreme and say, NAR, I order you to issue a rule that says MLSs, you are forbidden from having a platform or including any offer of compensation in the MLS. He can do that. Now, the question becomes, is that an order for only the state of Missouri? Or can he argue, hey, look, in front of me, this case happened in Missouri, but the damage is billions of dollars out across the entire country. I think he absolutely can, at least at this level, argue, I have the authority to protect consumers across the whole country. And I'm going to issue that order that the NAR change your rule in that way, right? That your rule has to say, to be an NAR MLS, that you cannot have compensation. I think he can go that far.
Okay, but he can't. So in other words, he can't be detailed in the way that like the FTC could be detailed.
No, his order would have to be to NAR on what NAR's rule would be.
Okay,
that's
so
the context.
Can he write the rule for them?
He can't just make an edict that brokers out there can't share commissions. No, he doesn't have that breadth.
Right. So, can he craft a rule for NAR? Say, hey, NAR, I'm ordering you to implement this rule in your code of ethics or MLS handbook.
That would be the top level of his potential authority. And would he be on a little bit of shaky ground? Maybe.
Okay.
And I'm sure they could have a back and forth too. Like maybe then NAR comes back. What about this language? Right.
Correct. He could propose a rule. NAR could have a hearing.
All right. I know we got to wrap, but I have a final question because this, again, I brought it up and I don't have a real clear answer on this. Supersedeas bond or the appeal bond. If NAR should lose Burnett, they have, publicly taken the stance. Don't worry. This is going to be years because we're going to appeal it, etc. And then I learned about it, and I think it was from you. Yeah. Before that though, you have to post this bond.
Yep.
So let's talk about the bond. And I went in a little bit into it. It's like, it seems a lot more complicated than it seems. Let's say damages out of Burnett. Again, that no one can pay, right? But the damages are $4.5 billion.
Okay. And that's a possibility with what the plaintiffs have claimed.
Right. Yeah. That's what the plaintiffs have claimed, right?
Yep. So
and NAR wants to appeal that. What is a bond they have to post?
I have to do this because I'm a lawyer, right? Federal Rule of Civil Procedure 63. What it does, it gives you a 30-day stay from the time the judgment gets entered until such time that the defendant has to cut their check. And the plaintiffs can start actions to try to collect. That's all you get, 30 days.
Right.
Appeal or no appeal. What most people do, and that's also, by the way, the time it takes to appeal. So the concept is if you're going to appeal, you go back to this judge and you have a bond hearing. And here's what so the judge has these competing interests to weigh. On the one side, he has in front of him a plaintiff that proved their case to a jury and got an amount of money. And that plaintiff should have some kind of insurance that if he wins these future appeals, because he went through the court process, that he should get his money easily. On the flip side, the judge has to balance the interests of a defendant who maybe got screwed at the trial process and there was an error and that they shouldn't have to pay money that they don't rightfully owe pending their appeal. So the judge has to put these two competing interests on opposite scales. Here's the perfection of a spot of an amount that the judge wants to pick. As a judge, I want to pick an amount for this bond that evaluates the payability, viability of the defendant. And I want to pick a number where the lawyers on the defense are pissed. They have meetings with bankruptcy attorneys the next week, and they eventually decide not to file bankruptcy. That somehow they think they can pull through with this amount of money, figure out how to get some liens on some property, freeze up some of their stock assets, and get the money in the way it needs to be without having to file bankruptcy. That's the perfect spot that the court's looking for. The court prefers that no one files bankruptcy, but wants it to be as high as possible right up against that level. Now, what happens if the judge hits it and you have 20% drop in membership the next year, right? You can still end up with a bankruptcy. Or worse, what happens if a judge misses and pins it too high and causes a bankruptcy? Those are all possibilities.
So the important point here is that the damage award could be $4.5 billion, but the judge could come back with, listen, the appeal bond is going to be 1.2 billion, something like that.
Well, it'll be the bond will be per defendant. So let's look at NAR, right? With what do they have? 650, 700,000 in cash and cash equivalents.
No,
right?
yeah, no, I thought they had 300 million or so in cash.
Okay, so 300 million in cash, but you still also have equity on properties,
right? They have about $1 billion in assets.
Yeah, so you have $1 billion in assets, right? But how much of that billion is really
liquid,
right? So if you have an interest in a stock, you don't get to have 100% of stock because what if it goes down, right? So there's that kind of analysis is what's going to be done, and maybe he picks a number at 400 million or 500 million, right? Enough that they won't have to file bankruptcy, but they are able to still function. Maybe it's 250 million. I don't know that number. That's for accountants and those kind of guys to figure out. But it's not the full value of the case, and it's not meaningless. Right. Okay. It is a substantial.
Okay. That's what I wanted to know, because the way the federal rules are written, it sounds like it has to be full value of the judgment plus interest.
Correct. Right. Plus potential lawyer fees. Right. So the top end number can be really high, but in this case, it's irrelevant. It'll never be close to the top end number. It's going to be a number with the court balancing these various interests between protect the plaintiff as much as I can without causing the defendant to go bankrupt.
All right.
That's the balance point.
All right. Man, we could go on and on.
Yes,
we should have had you on longer. Like, we'd love to have you back, man, especially as the next couple of weeks, progress and we're starting to hear reports from the actual trial itself. But this was great, man. This is something that should have happened weeks ago, months ago.
Yeah.
This is all going to be settled anyway. So, it's, I think next week.
Break stamp. I think eventually it'll get settled, but I think we'll have some exciting times for the next couple of weeks of at least seeing a trial. And then depending on what happens, it'll either settle or NAR will win. I think one of those two things is the likely event 3 days after. And I'd like to end with this comment. Don't freak out. Don't worry. It doesn't matter. The MLSs will be fine. Buyer agency is alive and well and will be fine. And don't look at this as some kind of existential ending event. We will get through this and everything will be fine and maybe even better.
All right.
Thanks, Ed.
Let's leave it there. Thank you very much, Ed, for joining us. Thanks everybody for listening to us. Goddamn yammer about legal stuff. I mean, seriously, Greg, we got to do an episode like talking about, I don't know, like sexy dances or something. Like we got to, like our topic.
You can't handle the truth. That's what I want to do.
You can't handle it, like something. So thanks everybody. Ciao.
Listen, content is everything. Two Brothers Creative makes it look easy. Right now, business owners really only have two options. The first option is hire a big firm. Now, this big firm's going to come in, make you think that they invented all the algorithms, and start charging you thousands of dollars every month. You don't want to do that. Second option is to do it yourself. Well, that means you got to learn SEO, SEM, copywriting, marketing techniques on the web. You should be really focusing on your own product. But now there's a third option. It's called Content in a Box. Give Two Brothers Creative 30 minutes a week and they'll handle everything. Plus, they'll show you how to bring it in-house later on. They'll rebuild your marketing foundation and give you tools and techniques and a new marketing playbook that'll actually produce real results and help you grow your business. Two Brothers Creative will give you the confidence and know-how to tell the SEOs and SEMs and all those other acronyms to get fucked. You're in control now. Get started today at thecontentbox.com.